As everyone starts to come in, I'd ask that you just mute your sound. You can decide whether you want to stay on with your video or not. That's up to you. Depends on, I guess, whether you're wearing your pajamas or not. All right, everybody. It's great to see so many familiar faces and names here to this afternoon. I'm so glad that you've been able to join us. Again, as people join, please remember to mute yourself. It'll make it a lot easier. If you want to stay on with video, that's fine too. And again, so very much appreciative that you've joined us today for our CLE program on title insurance claims and coverage litigation. Most of you know me. To the extent you don't, my name is Trip Riley. I'm a partner here at Saul Ewing, Arnstein and Lair. I'm the co-chair of the title insurance practice group and also a co-chair of our consumer financial services litigation and enforcement practice group. A number of my colleagues that's here at Saul Ewing have graciously agreed to provide their time today to put on this presentation, and I'm very thankful for that, and I'm sure that you will enjoy it. Our first hour, will be focused on title insurance claims and coverage litigation. Then will be followed by an ethics portion, and the ethics will focus on relationship between claims counsel managers and the insured. And then last, we're going to do a segment on preparing for a title insurance type of trial. Before we begin, however, though, I want to start with a little bit of housekeeping. Again, please mute your lines so that there's no background noise for those who are listening as well as those who are presenting. And you can also stop your video if you want, but that's really up to you. We're going to take questions at the end of the presentation. However, you're welcome to use your chat function so that you can get your question in, and we will do our best to answer those questions with the time allotted. But if we can't, then certainly I or someone within the group will follow up with you directly. The program is being recorded, and that recordation and the handouts that you will see will be sent to you either this evening or tomorrow, so that you'll have that. This is a CLE program. It's approved by the approved for continuing legal education in Pennsylvania, New Jersey, New York, because New York recognizes New Jersey, Delaware, Florida, and Illinois. As an accredited provider, we'll need for you to verify your attendance. Most of you have probably attended these before. So several times throughout the presentation, we're going to provide you with a numeric designation or so that you can write those down in those codes down and report back to us with those codes when you fill out your information and send us back your CLE application so that we can then submit those for you. If you happen to be looking for CLE from other states that I did not mention, I think there are at least a few states that you'll be able to submit that directly to the state and seek credit. I have to read this little disclaimer. The provisions and receipt of the information in this presentation is not legal advice. does not create a lawyer-client relationship and should not be acted upon without seeking professional counsel who have been informed of the specific facts. So with that, again, very much appreciative that you guys have been able to join us, and I will now turn it over to my partners, Caitlin Strauss and Mike Joyce, who will begin the presentation on title insurance claims, hot issues in litigation. Take it away.
Thanks, Trip. Good afternoon, everybody. My name's Mike Joyce, and I'm going to start off this part of the presentation. I'm a partner in the Pittsburgh office of Saul Ewing. I'm a commercial litigator, but within that category, I do a lot of insurance work, including title insurance disputes. So thank you for joining us today. I want to cover first some of the high-level considerations, the risks and the benefits of litigation and title insurance cases. Figuring out a smart litigation strategy early on in the case is vital to chart the course to success. And as you'll hear shortly, success can mean different things depending on the case. Next slide, please. So to begin, some of the cases I've handled on behalf of title insurers, particularly when the insurer is the plaintiff, can create some unique challenges when you try to begin to determine case strategy and structure. And that uniqueness often comes from two competing concerns that create an underlying friction. And the first is that many of the parties that insurers deal with are undercapitalized, which means that there might not be a pot of easily available money to fight for. And then second, the conduct that's at issue is often really, really bad. It's sometimes criminal, meaning that conduct needs to be stopped through the legal process. So balancing these concerns, making sure on the one hand, there's an upside for the insurer client, while also protecting the insurer's interests against the bad actors, it's a key consideration from the beginning. And one of the benefits for title insurers when they're litigating against some of their contract parties, whether that be a closing agent or somebody else, is that the insurer has control often over the contract. So there's significant power to be had there when you're in control of the terms. Depending on the nature of the case, there could be a variety of relief available. The most classic form is just direct and other damages. That's a money judgment for what's been lost. Sometimes, particularly if it's in the contract, you might have a chance at attorney's fees and costs. This certainly provides leverage and an extra layer of protection in the case of dispute, but it's possible that these provisions aren't as powerful depending on the other party you're dealing with and whether that would ultimately be a form of collectible relief. Third is the potential for injunctive relief. Sometimes it's necessary to have the court compel a party either to do something or not to do something, and you can pair these injunctions, with some of the other relief with money damages, things like that. And last is criminal penalties. We as private parties ultimately don't have control over whether or not a criminal investigation or charges are brought, but we can certainly tip off authorities or try to encourage authorities to act. This can provide significant leverage above and beyond some of the other categories because frankly, nobody wants to go to jail. But oftentimes you'll see little appetite from law enforcement for some of the more run-of-the-mill cases. So it's certainly a hammer that might be available, but not always. The key consideration I talked about is the juice worth the squeeze? It's a quote I've heard a bunch of times, and it rings true here because ultimately, is the effort going to be worth the outcome? I've seen it in a lot of commercial litigation cases where harm might have been incurred, but ultimately you have to consider what you stand to gain at the end of the case. And it particularly comes into play in these title insurance cases, when you're dealing with defalcation and things like that, because there's normally a reason the money was taken or a reason the bad act happened, and it might not be always easy to reclaim it. Doesn't mean you give up, but instead the path to victory might just look a little bit different than initially anticipated. And a funny story I ran into was in a non-title case. We actually ended up winning a judgment. We were involved in a companion case, and the government was going after a party for around 15 or $20 million in losses. Everybody was very excited because there was a big locker of rare art that was in Florida. When we had an expert go through it, it turned out that it was all reproductions or prints. So not the jackpot you were thinking of. Instead, it was basically a home goods store sitting there on the lot. So that's the type of letdown we ultimately want to avoid at the end of the day. I've had two cases, and I'll just discuss them briefly because it shows that these cases take twists and turns, and an appropriate strategy is important to get the right result. And one of those is a defalcation case where you had the owner of a closing company siphoned off hundreds of thousands of dollars of money from the closing accounts. The company was busy enough for a while to hide it, but eventually that money ran out. And this person used the money to buy a motorcycle and a home in Myrtle Beach and all sorts of personal things. And what we did was, when we found out, we were able to immediately jump into action. We obtained a preliminary injunction, which froze bank accounts and also required the production of documents. After seeing those documents, we were able to do some discovery and really get our hands around ultimately what was happening in the case. And from there, we realized, unfortunately, 100% recovery wasn't practical, and it might have been impossible, particularly because the owner filed for bankruptcy. So at that point, we had to chart a new course, and we were able to have the court liquidate the frozen accounts. We leveraged a settlement with an employee, and then ultimately we also went through the bankruptcy court, and there's still monthly payments that are coming in from that as well. And I think ultimately the important takeaway is that these cases aren't always linear. You might not have a scenario where there's harm, you litigate, you win, and then you're made whole. So tough strategic decisions are not uncommon in these offensive actions on behalf of title insurers. It's just the unfortunate nature of the beast. Next slide, please. So the $1 million question is, what do you do about it? What are the solutions? And there's a couple different ways you can approach it. Again, if you don't have that sort of linear classic litigation where you can go through the normal process. Sometimes goal number one has to be stopping the offending conduct through an injunction. And then, hopefully everything after that is gravy if any money or any other relief is available. It's important to remember that, there might be an alternative forum through bankruptcy court or through some other venue to pursue relief. What we've used effectively at times is consent judgments. If you're able to back the other side into a significant corner, sometimes you're able to get a consent judgment, short of full litigation, and that's often an efficient way, at least to obtain the right to monetary relief. You can also get creative within a settlement or a payment plan. Could be a forbearance agreement. If it's a situation where 100% recovery is unlikely, you might be able to mitigate through settlement to get the certainty, get the efficiency of that result under the circumstances. Sometimes wait and see is the best way to do it, which is tough to say as a litigator, but rushing through a collection process or being overly aggressive might not be the best choice. It might make more sense to wait for more opportune time to act. I mentioned earlier, but you might be able to see some leverage through other proceedings, particularly if you can get some traction on the criminal side. And ultimately, you should search for deep pockets. Anybody you can find who might be responsible for the losses, bring them into the case and try to, again, mitigate that delta. And last, there's times, unfortunately, where it's not economically ideal to pursue it, but it's important to set a precedent or to send some other sort of message for future cases to help in those as well. Now I'm going to pass it over to my partner, Caitlin Strauss, who will continue the discussion about damages and some related issues.
Thank you, Mike. It's nice. Mike, can you just tell me, can you hear me okay, everyone? Just make sure I can't see anybody. All right, well, assuming no one complains, I'm hoping everyone can hear me just fine. My name is Caitlin Strauss. I am a partner in the Philadelphia office of Saul, Ewing, Arnstein, and Lear. It is lovely to see a lot of names on the side of my screen, many of whom I've worked with on some of my favorite cases. I am an insurance attorney. I do a lot of title work, including with many of you on this call and with many of the partners that are co-presenting with me. And so I enjoy these cases, and I'm happy to talk to you this afternoon. You'll hear from me in this presentation and then the ethics presentation. I am a resident in our Philadelphia office, but I am also barred in New Jersey and New York. So I cover a little bit of the East Coast for these sorts of claims. All right, getting into my portion of the presentation, I'm going to talk a little bit about consequential damages to insureds resulting from delay in resolving title claims. And this is an issue that has come up more frequently than you may expect, although some of you are hopefully nodding your head saying, yep, this is something I've dealt with in my cases. Next slide, please. So the issue that we're going to discuss and see how it comes up, discuss some recent cases and how to address it, occurs when the insured alleges that there are title issues and the delay in resolving those title issues is impeding an insured's ability to move forward, causing them damages and preventing them from using the property as they would like to. Next slide. So here's the policy language that is implicated, or some common policy language that we're going to dissect a little bit that many of you have probably dealt with. And it says, if the company establishes the title or removes the alleged defect, lien, or encumbrance, or cures the lack of right of access to or from the land, and goes on to say, in a reasonably diligent manner by any method, including litigation. So there's the key piece there that's highlighted in bold on the slide. And you've gone through the litigation process, the insurer shall not be liable for any loss or damage caused to the insured. Okay, so let's talk a little bit about that. Next slide, please. So we're going to talk about some real world examples where, quote, reasonably diligent manner and real world litigation can conflict, and what can an insurer do in those circumstances? What does it look like, and how can we deal with those situations? It's most recently come up for me in the last 2 years because of COVID. That has created delays that are through no fault of anyone, but delays in the court system. I had a case for an insured where, due to court closures, it took us 6 months to get a complete consent agreement that was agreed to by all the parties, but needed to be entered by the court. It sat for 6 months just because there were delays in the court, and I had the insured, contacting me saying, we need this order to proceed, and there wasn't much I could do about it, just because the courts were closed and they were trying to get through their backlog. So that can create problems that just hopefully, as the world starts to reopen, will we won't see so much anymore. Similarly, I've seen cases as well where you've got a lot of parties involved. Oftentimes, title litigation brings up not just the insured, but there's lots of other parties that need to be brought in, and that can cause delays going through the process of litigating not only just the underlying claim, but cross claims, counterclaims, and all the other claims that you have to go through in the process. I've seen this more as an issue in a commercial real estate context, less so than in residential real estate title claims. And I think that has to do just with the damages and what parties that insureds that are looking to insure a commercial real estate transaction are expecting, necessarily more so than in a residential transaction. So what can you do? And I've had this question asked to me from in-house title counsel. Do I pay the claim? What do I do? Next slide, please. So when you've got multiple potential parties responsible, this becomes an issue, and sometimes you can't just pay the claim and then proceed with the litigation, so that you at least get the insured to stop breathing down your neck, complaining about the delay. Sometimes you just don't know if even the insured is the one that you should be paying, or is it somebody else? Are they involved if it's a fraud case, or are they to blame, and do you have some potential claims against them? So in this situation, I think you just have to get everybody to the table and proceed as quickly as you can, including one of my favorite defendants. And I can say this because I'm in good company with, I don't think any banks on the line, but banks as potentially liable defendants. And this is a potential defendant that I've seen in multiple cases who are sometimes the most difficult and most vigorous defendants when they're brought into a title claim. But they're a potential deep pocket. Next slide, please. So banks as potentially responsible party and the duty to a non-customer, which is the standard line that you will often hear when you have a bank as a potentially responsible party. I'm going to just discuss briefly a recent case. This is an unreported opinion out of the District of New Jersey, and this case was actually cited to me in a title case that I had. This was a fraud case, and the court dismissed the case against Wells Fargo on the basis that there was no duty owed to a non-customer. And in this case, the plaintiff, Fred DeFazio, had intended to purchase real estate, but he was duped into wiring funds to someone other than the property at issue's owner. And I think that's a scenario probably many of you have encountered. After recognizing that he was defrauded, DeFazio asserted claims against Wells Fargo, the bank at which the alleged fraudster maintained his bank account. Among other things, DeFazio asserted that Wells Fargo had negligently breached a duty owed to him because the bank, 1, allowed the alleged fraudster to open an account, 2, permitted the transfer of funds into the account, and 3, permitted the alleged fraudster to withdraw funds from the account. And the court dismissed these claims with prejudice, reasoning that the bank owed no duty to non-account holders like Fred DeFazio. And I suspect that is a refrain you have heard before, and I'm going to tell you how I've gotten around it. And the next slide, please. So a customer contact can trigger liabilities to third parties. And this is a case I've relied upon, the Liberty State case. It's a bankruptcy case, and it has a great quote that you can feel free to use in your next filing. It says, even in the absence of a formal agreement, banks may owe a duty to non-customers on the basis of a contact. And in this case, a bank was found to owe such a duty to those non-customers which it has a direct relationship. And so in this matter, the bank moved to dismiss, but the court held that the negligence claim survived a motion to dismiss. Next slide, please. So how do you determine what a contact is and whether you have it in your case or can make this argument? So the test that was cited by the court here was a contact is determined by analyzing the surrounding circumstances and by examining whether the bank was on notice of the non-customer's special needs. And in this case, I think somebody's not on mute. I can hear typing. Sorry to everyone could just check to make sure they're unmuted. Muted, please. Thank you. And in this case, the court refused to dismiss a negligence claim, reasoning for a number of factors that they had. The bank employee was notified the moment that a payment was wired into a trust account, so the bank was on notice. The debtor then immediately laundered money from this trust account, but the bank failed to investigate the payment despite knowing that the account was a trust account. And the bank argued that its employees did not know who the beneficial owner was of the trust account, but the court found that the plaintiff had pled enough facts to suggest otherwise. So in this case, they succeeded in keeping Wells Fargo in the case despite their protesting. I had a similar good fortune in a case that I had where Wells Fargo similarly was the bank where funds were wired from the insured to who they thought was the owner of a property, and it turned out was just someone impersonating the real owner. And prior to naming Wells Fargo in a third-party action, we did some discovery and got a lot of really great documents from a third-party subpoena directed to Wells Fargo, which showed that this account was on Wells Fargo's radar. There had been a number of other fraudulent transactions that had occurred in the account. Wells Fargo shut down the account almost immediately after the transaction that was at issue. And so we succeeded in arguing, at least at the motion to dismiss stage, and fighting off Wells Fargo's motion to dismiss, that Wells Fargo had actual knowledge of the questionable activity in the account, and thus had a duty to either close the account or at least warn foreseeable victims, such as the insured, in my case, who had wired a significant amount of money into the account and warn them of the questionable nature. And ultimately, in that case, we did resolve it, but it was helpful at least to keep Wells Fargo at the table and ward off a motion to dismiss. Next slide, please. I'm going to talk about another recent case that some of you may have heard of. It's a Florida Supreme Court case which deals with the issue of extra contractual damages. Next slide. And here's the citation for the case in case anyone wants to look it up later and read it in its entirety. It's the Citizens Property Insurance case this year in 2021. Next slide, please. Here's the case background. The case revolved around the destruction of an apartment buildings from a hurricane in 2004. And those citizens, the insurer, paid the initial claims. It failed to pay subsequent related claims. Next slide. So after the insured filed a suit in 2007 to recover on all its claims to citizens, it was ultimately awarded an additional $5.5 million. The insured, however, lost significant rental income while it waited for the additional claim to settle in the amount of around $2.5 million. Next slide. The insured sued citizens again on the grounds of breach of contract and fraud to recover this additional $2.5 million that it lost during the delay. Next slide. And the Florida Supreme Court reversed the district court's holding, which denied summary judgment to citizens. And according to the court, and here's some helpful language, extra contractual consequential damages are not available in a first-party breach of insurance contract action because the contractual amount due to the insured is the amount owed pursuant to the express terms and conditions of the policy. Next slide. The insured seeks to recover extra contractual consequential damages in this case based on citizens' alleged failure to timely adjust the loss, wrongful denial of the claim, and delay and failure to timely pay the claim. Something, again, I'm sure many of you have heard. These allegations are found in a first-party bad faith action where an insured sues his or her own insurance company for improper denial of benefits. The bad faith action was unavailable here because it was a government entity. Next slide, please. But the takeaway here is that this is a recent case. It's always nice to have one, a new one, such as one from 2021, affirming that a bad faith claim is the proper avenue for an extra contractual damages claim, but not the first party litigation. And I think this is significant because a lot of times I've heard insureds try to tie everything together in the first party claim and try to bring in the extra contractual damages claim improperly when you're negotiating in the context of the initial litigation. And with that, let me turn it back over to Mike.
Thanks, Caitlin. I want to touch on a little bit of a different type of litigation. Some jurisdictions have streamlined statutory processes to resolve certain title issues, and that's normally reforming deeds and other documents that have been recorded. These are state specific, so again, it depends on where you're venued, but a lot of states have passed this sort of legislation. And absent the streamlined process, you could be stuck in a full litigation to resolve these mistakes or typos or things like that. So there's certainly a significant benefit. Ultimately, you also might see an uptick in these cases involving mistakes on deeds or mortgages just due to the current economic climate. You know, you have economic issues that could lead to foreclosures, which will very likely reveal mistakes in the underlying documents. Or just considering how hot the real estate market is, the mistakes might be uncovered during those transactions. So you might see these so-called sleeping defects awaken, and really the pace the transactions are occurring now could also lead to errors on the documents. Next slide, please. And so in the normal course, if you have a mistake on a deed, a mortgage, or some other document that was recorded, you normally have two primary ways to resolve it. You might be able to go through a correctional deed. Normally, you need the signature of the other side, and depending on the circumstances, you might not be able to get it. If a foreclosure is imminent, if the mistake is in favor of the other party, there might not be an appetite to consent. So this is a quick and efficient way to resolve those sort of issues, but it takes two to tango here. The other route is litigation. If there's a mistake in a filed document, you can always file a complaint and explain to the court why the mistake should be remedied. But this is an adversarial proceeding. It takes time, it takes money. You don't necessarily need the consent of the other party, but now you bear a burden with the court to prove why a reformation is necessary. And that's not always easy to establish. A mistake, in courts just really aren't open always to changing documents that have already been settled. Luckily, a lot of states have enacted these statutes that provide an intermediate option, a streamlined option that can be pursued unilaterally without the consent of the other side. I'm going to focus on the West Virginia version just because I'm currently litigating it, and I think it's the most recent one of these types of laws that was passed. But under the West Virginia Code section 36311, which deals with correcting errors in deeds of trust and mortgages, this type of process exists. The statute was effective just in June of 2020, and it applies to what's described as obvious description errors. This means that the error must be apparent from reference to other information or documents. So it might be a typo in an address or a tax ID or something like that. The way the process works is if some sort of issue is identified and it fits within the statute, you have to give notice to the relevant parties. This is anybody on the original documents, adjoining landowners, people like that. You wait 30 days for objections, and if no objections come up, then you can file a corrective affidavit, and the corrective affidavit applies retroactively back to the date of the original filing. So the process is pretty quick, pretty easy, assuming the statute applies. There's little case law, particularly under the West Virginia Code, and really, if you look at any of the statutes, they're just not frequently litigated. So that's good because you have gray area, and if you're trying to stretch the statute a bit, you don't necessarily have a case telling you no. But of course, where there's gray area, there's also risk. Under the West Virginia statute and a lot of the others, there's also a downside to relying on the procedures improperly. Can be liability not only for damages, but there's often fee and cost shifting provision. So that could be a significant problem if you stretch the statute perhaps a little too far. Right now, I'm handling a case which I think is sort of in that gray area. It's in the border area. It's in rural West Virginia. It's in an interesting part of a rural county where a family and family members own a bunch of adjoining properties. Ultimately, there were 2 plots of land that were supposed to be used to secure a mortgage. Title insurance was issued on both plots, but for some reason, when the mortgage was finalized and recorded, it only identified one of the plots, which is obviously a problem, particularly because the bank now wants to foreclose on both of those properties. Helpfully, the recorded mortgage did incorporate or reference an underlying deed that had descriptions of both. So right now we are using the statute, and so far successfully, to attempt to reform that mortgage. So both plots of land are in there to make way for the ultimate foreclosure proceeding. It's not the perfect definitional situation under this statute or a lot of others, but we think it fits, and ultimately the upsides of relying on this statute outweigh the risks, particularly when, again, you're facing a full litigation process otherwise in a lot of these situations. There are similar options in other jurisdictions. Virginia was the model for West Virginia, so they're nearly identical. California applies to minor corrections, and so it's typos, illegible text, things like that. North Carolina uses the phrase non-material typographical or other minor error, and specifically says it cannot impact the substantive rights of the parties. And then you see a lot of the statutes, Michigan, New Mexico, Florida, use a scrivener's error or omissions type language, again, with the caveat that it cannot impact the substantive rights of the parties. So in the end, these statutes, have you heard, they're available for minor mistakes, typos, things like that. More substantive issues might still need to go a different route, including litigation. But it's important to keep in mind that you might not need that lengthy litigation for certain issues in recorded documents, depending on the jurisdiction you're in. And so while we're talking about recorded documents and the recorder's office, the last 2 years or so have been an interesting time for recording documents and for all court procedures, but the recording offices have become an even more difficult place to be with the pandemic. You have a hot real estate market, which means you have a lot of transactions happening. You have COVID closures. Most of those are probably unannounced. You have archaic procedures in a lot of these offices, particularly rural counties. And then you have delays in the mail, which is really a new thing, that a traditional method of filing that was considered, pretty automatic is less than certain. And so altogether, you kind of have the potential for the perfect storm. Plus, there's an overall difficulty in just finding the help you need in the industry. The real estate business is not immune to the labor shortages, and the industry is busy. So just finding help for simple transactions can be tough. I needed a survey done in West Virginia, and it was tough to find a vendor who wanted to do it, let alone at a reasonable price. And so all of this just injects more uncertainty and more time into the process. And of course, when there's delays and when there is uncertainty, that's where litigation occurs. Ultimately, the time lapse for gap closings has the potential to be longer than ever. That intervening time period between when the closing documents are signed and ultimately recording the documents might sit in an empty recorder's office or potentially be subject to any number of the other issues that I discussed. And as that gap lengthens, that's when an unexpected encumbrance or some other issue can interject in the chain of documents and impact the transaction, which again causes issues, causes litigation. That's where the problems lie. Unfortunately, there's no perfect solution to it, but there's a few things that can help. The first is speed. Speed is our friend here. Get things as quick as possible through an overnight delivery, in person or e-file. Time is certainly of the essence more than ever. The next is that protections can sometimes be worked into the documents, whether it be gap indemnity, disclaimers or covenants, or caps on coverage. That all helps spread out the risk. And last, to the extent you can, knowledge is powerful in these situations. So trying to stay up to date, particularly where a lot of business is done, relying on local resources, those are all going to be our friends here. And even if there is mitigation, of course, there's still risk for litigation. If everything happens perfectly, if there's a delay in an issue, there still could be challenges to any disclaimers or indemnification. There's going to be disputes over who bears risk, disputes over priority. And of course, the recording office is likely not going to be liable through governmental immunity, and it's going to be left to private parties to sort it out. So unfortunately, these recording office delays are another reality and risk of the current environment we're trying to operate in. To get away from the recording office a little bit, I just wanted to touch briefly on some policy form changes that came from ALTA, from the American Land Title Association. These changes went into effect back in July of this year, so they're still relatively new. They were the first change since 2006. That was a pretty significant rewrite back then. But incredibly, it's been 15 years, and so a lot has changed. And ALTA is doing its best to clarify some terms, explain coverage and exclusions. And I think the point of the rewrites or the revisions is to reduce the potential for litigation. But of course, anytime there's change, even if it's with a good intent, litigation is possible. How do we get here? What's the basic ALTA process? Starts with the concept. ALTA listens to the industry stakeholders about issues and improvements. They do their best to keep up to date with regulatory changes and other changes in the law. And ultimately, they come up with an idea that's the potential for a change to the forms. This concept gets passed through a forms committee, which develops the updates. And then it needs to be approved by the ALTA Board of Governors. If it makes it through that, after that internal approval occurs, it goes through a public comment period before implementation. So right now, those forms are available. Underwriters I think are doing their best to get them approved at state level and things like that. So we're certainly in a transition period. And I'll ultimate a number at the end of the day, a number of tweaks to different forms. And you could really spend a long time going line by line. I'm not going to do that today because we don't have time, and I do want everybody to stay awake for presentations of the rest of my colleagues. So I'm going to just briefly cover a couple of the changes that jumped out to me. On Alta's website, it does have a really nice chart that shows the 2021 revisions side by side, redlined with the 2006 versions, and then provide some commentary. So if you're so inclined, that's a really great tool if you want to see the specific changes that occurred. The first one up is everybody's favorite topic, federal ag and other statutes, particularly the Perishable Agricultural Commodities Act, which is PACA, and the Packers and Stockyards Act, which is PASA. These are federal statutes that create a floating trust, operate similar to a secret or an automatically springing lien on all the assets of the purchasers of certain agricultural and livestock products. The updates to the forms from Alta have made clear that only recorded PACA or PASA liens are covered. And if they're not recorded, if they're just kind of those secret or springing liens, they would be excluded. So this has been, I think ultimately it'll be reducing liability for insurers and just avoiding surprise overall. The next is there were a number of tweaks to the definition of insured. One where there were some issues in the past was whether an affiliate or related party of the owner is ultimately also covered by the policy later. The new definition includes situations where property is conveyed from an owner to an affiliate with a monetary exchange. For years, it was conditioned on that property being delivered without payment of actual consideration. So again, it's an expanded protection, this time for the insured or related parties, gives a little more flexibility to those sort of transactions. The updates from 2021 also included a new definition for a new phrase, enforcement notice, and it just makes clear now that and there wasn't necessarily a material alteration of the other definitions, but again, in the interest of clarity and avoiding litigation, an enforcement notice now is defined as a document that's recorded publicly on any part of the property, and it includes a violation of government regs, laws, agency orders, things like that. Next is there is some more flexibility for insureds now as to how to calculate losses. It used to be that the forms were silent on what value of property meant to determine damages, and the updates clarified first that it was fair market value. And second, the insured in certain situations can now choose the date when that fair market value might be calculated. So it's going to give insured some flexibility as to potentially taking advantage of market conditions to improve their situation, but they might be able to elect the date the claim was received, or the date of a foreclosure, the date of the policy, or maybe even the date of discovery of the defect. The definition of public records was also updated. It was meant to clarify what recording or filing systems ultimately provide constructive notice. And it specifically says that filing systems created by state statute, so that generally exempts environmental protection, statute filings, planning, permitting, and zoning boards, things like that. It's essentially the same as it was in practice, but again, more clear to avoid potential disputes there. And the last update was, I think, a much welcomed one, but Alta caught up pretty quickly with remote online notarization. Now brings the forms in line with really developing tech and the industry-wide movement towards these electronic transactions. Also is tracking national legislation trends and things like that. It's ultimately interesting because there's still courts and there's other, judicial and government bodies that still won't accept electronic signatures. But it's nice to see, the business world catching up here. And as you see at the bottom of the slide, CLE code number 1 for purposes of your CLE credit, that code is 87734. And again, yeah, you need to write that in your survey to get the CLE credit. And that code number 1 is 87734. And so, you know, I touched on some of the changes, and there's a number of other ones I won't get into. The Alta resources on the website are great. And I think, you know, again, what you're seeing is Alta doing its best to tweak the forms and the other information to keep up with the industry. You're not seeing giant changes or hugely significant changes. Through these updates, you're seeing clarifications and fine tuning. And I think this is the last section that I'll cover for the presentation. So I just wanted to thank you all for joining us again today, listening to the presentation. I hope it is and continues to be informative, and I'll send it back to Caitlin to continue our discussion.
Thank you, Mike. All right, I'm going to bring us home with the last portion of the first hour of our presentation with a fun topic, the I didn't know or I didn't read as a basis for a policy claim and how to defend against those arguments. So lack of awareness as a defense to policy claims, and I'm going to talk a little bit about a real world case that I've had and how we successfully won in that case. And in this case, it involved a spouse who fraudulently signed his wife's name to a refinanced mortgage, and the wife tried to argue that it couldn't be enforced. There was lengthy litigation. This was a mortgage coming out of the 2008 time period. The husband did, in fact, sign the wife's name to the mortgage, but the wife nonetheless made payments on the mortgage for years. And as discovery would point out, the payments that she made on the mortgage were from a checking account that she had in only her name. She assumed the mortgage, although it wasn't identified as cleanly as we would have hoped, as part of her divorce settlement. And then when the wife faced financial difficulties, her husband had unfortunately forged her name on a lot of mortgages for different properties. She tried to argue and just simply stopped paying the mortgage, which ultimately led to a foreclosure action and years of litigation. We got involved when the insured on the mortgage sought to defend against her claims that the mortgage couldn't be enforced because her signature on it was forged. And after years of discovery and a lot of ugly tactics from her counsel, ultimately we succeeded in obtaining summary judgment, in large part due to the discovery that we had obtained at great length and great time, but got discovery that showed that she did in fact know about this mortgage, even if her signature wasn't on it. And ultimately the equities prevailed, and the court rejected her argument for an unclean hands defense and held that an equitable mortgage should be enforced. It's always nice to get summary judgment, especially in state court. In Pennsylvania in particular, where I practice, it is often difficult to prevail, particularly under facts where you have a somewhat sympathetic plaintiff. Ultimately, at the end of the day, the equities did prevail. And there we have it there, the equity and the takeaway there. Okay, so another case study that I'm going to focus on along the theme of the I didn't know or I didn't read concerns a homeowners association that was hidden in the countryside and also the deed restrictions. And this was a case involving property in a very rural area, which you wouldn't necessarily suspect that there would be a homeowners association or deed restrictions, as you might suspect in a place where it's a more densely populated area and homes that look, like one another. And in this case, the buyers of a residential property didn't read the title policy. Because as they argued, the real estate agent had told them that there was no issue with the title binder and they could proceed with the transaction. Ultimately, there was, of course, a lawsuit when there were things in there that they didn't read. Next slide, please. All right, focusing on another real world example, fraud in a reverse. Oh.
Hi, my name is Sarah Kaiser. I'm the owner of the dog Simber, and we were looking to see if you guys had any appointments in the coming months to potentially have space to groom her. Can give more details if potentially necessary.
Oh, sorry. sorry, I got confused there for a second. I thought at first that person was speaking with me. Okay, sorry about that. Okay, fraud in the reverse name of a seller. Here's another lesson in reading closely. So we had a seller whose real name here was John Doe. We'll use that name for purposes of the presentation. And someone impersonated the seller and used the name Doe, John. And the title agent didn't notice the discrepancy. The closing lawyer did not notice the discrepancy. And other parties that were involved also didn't notice. The real estate agent, the bank who allowed the account to be opened in the name of Doe, John instead of John, Doe. Next slide. And in this case, there was a valid title insurance claim, which led to lengthy litigation, but also multiple parties contributing to the settlement. And this was the case that I had referenced earlier in my presentation. And ultimately, there was a valid claim here because the names were wrong, nobody noticed, and it was another lesson in making sure that your agents read closely when they're doing title work. Next slide, please. Let's talk briefly about a recent case out of the Fifth Circuit. And this case I like because it's got some really colorful language in it, which is memorable. And it's the Hall versus Old Republic case out of the Fifth Circuit. And the Fifth Circuit here upheld a title insurance policy striking covered risk 11A by the use of an ALTA form. And there's some colorful language we'll get to in the next slide. The plaintiff here was a construction lender and had provided the funds to a developer after it had began some construction work. The plaintiff obtained both a California and Nevada title insurance policies from the defendant, Old Republic here. And in negotiating the policy, the plaintiff had agreed to the removal of a specific provision of the standard form. And the provision covered losses resulting from, as you can see here quoted, the lack of priority of the lien of the insured mortgage over any statutory lien for services, labor, or material arising from construction of an improvement or work related to the land when the improvement or work is contracted or commenced on or before the date of the policy. And this coverage is exactly what the plaintiff then sought in its claim, despite having negotiated it out. The Fifth Circuit affirmed the lower court's ruling to grant summary judgment to the defendant. And in the opinion, the court wrote that the plaintiff must have real chutzpah to file a claim demanding coverage for a mechanics lien that was specifically stricken from the policy. And the court rejected the plaintiff's argument that other provisions, namely covered risk 2 and 10, applied because the assumption that other covered provisions apply to the facts specifically listed in 11A would make section 11A unnecessary and meaningless. And 2 basic principles of contract law dictate that the specific controls the general. Here, the addendum removing 11A from covered risks was too specific to read the contract any other way. And with that, that covers the last portion that I wanted to cover here today. I appreciate everyone's time in listening. And we have a few minutes left before we move on to the ethics presentation. If anyone has any questions while we have a few minutes.
Well, hearing none, I'm going to suggest that we move on now to the ethics portion of the presentation. And I see, oh, look, Caitlin, you're up again. So thank you, and we'll move on to the next section.
All right, you guys get me for another at least part of an hour. Ethical issues for the title insurance industry. And I'm gonna kick us off with just some background slides and then kick it over to my co-presenter to get into some of the substance. So what is ethics? I think it's a question we've all heard years ago when many of us were in law school. Here's some quotes from the dictionary as to what is ethics. It's a discipline dealing with what is good and bad and with moral duty and obligation, a set of moral principles, a theory or system of moral values, the principle of conduct governing an individual or a group. I'm going to throw in another definition. It is ethics is required for our CLE credit. And so I am glad you're all sticking with us to get some ethics CLE credit. All right, next slide. Legal ethics, code of professional conduct. What is required? What is permitted? What is prohibited? Some general principles of ethics. Next slide. Why be ethical? That's a question I hope none of us are asking, but it's because it's the right thing to do. Next slide. Ethic topics for discussion today. So we're going to cover a few things specific under the rubric of ethics generally, the attorney-client privilege, the unauthorized practice of law, e-discovery, and working remotely. And we're going to cover those topics somewhat generally, but also with a focus on what the folks on this Zoom presentation deal with every day, and that's the context of title insurance. And with that, I'm going to kick it over to Sunu to start us off with working remotely.
Thank you, Caitlin. Hi, my name is Sunu Pillai. I'm an attorney in SolarWinds Pittsburgh office. In addition to working on title insurance matters, I focus my practice on construction, both litigation and arbitration, and I also do some cybersecurity and privacy work. Next slide. So working remotely is a new reality for everybody. We are all remote today. But for attorneys, that this remote working raises some issues that are unique and that could pose a problem under the rules of professional conduct. And one of the first question is, what if the attorney is not living in the jurisdiction in which that person is licensed? Next slide. Now, why is that an issue? And that's because of Rule 5.5, because Rule 5.5a says a lawyer shall not practice in a jurisdiction, in violation of the regulation of the legal profession in that jurisdiction or assist another in doing so. So Rule 5.5 is a concern when you practice in one jurisdiction, but are not really licensed in that jurisdiction. Next slide, please. ABA Formal Opinion 495 addresses this issue. So the committee, essentially did not opine on whether in a particular jurisdiction, it will be an issue to practice the law of a different jurisdiction, but it said, absent a determination to the contrary by a particular jurisdiction, a lawyer may practice pursuant to the jurisdictions in which the lawyer is licensed, even from a physical location where the lawyer is not licensed. So essentially the opinion said, well, if the jurisdiction in which you are licensed or the jurisdiction in which you are living doesn't have an issue with it, then Rule 5.5 doesn't have an issue with it. Next slide, please. So the second part of Rule 5.5, it says a lawyer who is not admitted to practice in the jurisdiction shall not, number one, establish an office or other systematic and continuous presence. And number two, hold out to the public or otherwise represent that the lawyer is admitted. So the question under this part of Rule 5.5 is, if an attorney is living in a jurisdiction and working from a jurisdiction in which he's not licensed, he or she is not licensed, then have they established an office? And as you will see, the opinion essentially said, well, the second part of the rule answers that question. Next slide. So the opinion said the office is not established if the lawyer is working in the local, if the lawyer does not hold out to the public an address in the local jurisdiction as an office, and the local jurisdiction address does not appear in the letterhead, business cards, website, or any other evidence of lawyer's presence. So essentially, just because the lawyer is living in a particular jurisdiction, an office is not established in that jurisdiction unless the attorney is publishing that, hey, this is where I work. Next slide. And this says the same thing is so the lawyer's physical presence in the local jurisdiction is incidental. It is not for the practice of law. So that's the underlying reason for the ABA's opinion that it is perfectly okay to live in a jurisdiction and practice the law of another jurisdiction. Next slide, please. And the opinion goes on to say, the purpose of Model Rule 5.5 is not served by prohibiting a lawyer from working in another jurisdiction if the lawyer is for all intents and purposes invisible as a lawyer to the local jurisdiction. So this goes back to what the opinion said earlier, that if the attorney has not established an office, is not publishing anything in the letterhead showing the address in which he or she is living, then that is perfectly fine. An office is not established for the purpose of Rule 5.5. And multiple state bars have considered this question, including Pennsylvania and Florida. And we will go into the Pennsylvania opinion a little bit. And everybody had come out on the side that, hey, it's perfectly okay. I see we're having some problems with the slide, but next slide, please.
Bear with us 1 second, technical issues.
Sure, not a problem.
Sorry about that.
Right before that, I think it's slide 64.
Sorry, so no, I don't have numbers. I apologize.
Oh, that's okay. That's okay. The one before that. Sorry about that.
There?
Yep.
Perfect. Thank you.
Thank you. So, just to look at the Pennsylvania opinion, it was a joint opinion by the PBA and the Philadelphia Bar Association, only because there were a lot of attorneys who were living in New Jersey or who are living in New Jersey and working in Philadelphia. And that opinion said a Pennsylvania licensed lawyer who lives outside of PA in a state where he or she is not licensed may practice from home in the other state, provided the other state does not treat such remote practice as the unauthorized practice of law. So long as it is okay with New Jersey, it is okay with PA. Next slide. Now, the question about, the issues raised by working remotely for an attorney is not just whether it is an unauthorized practice of law, but the various issues that come up in a virtual work, be it practicing law or anything else, in terms of security, privacy. All those questions raise issues under the rules of professional conduct. Now, there is a recent ABA opinion 498, which addressed many of these issues. And it's set three major areas, where rules are impacted. And the number one is Model Rules 1.1, 1.3, and 1.4, which is the lawyer's ethical duties of competence, diligence, and communication. So competent in the technology for working remotely, diligent in responding to client communications, and communication the same thing. The second area is Rule 1.6, where the attorney has a duty of confidentiality to all of the clients. And the third area is 5.1 and 5.3, which is essentially supervision of subordinates and non-lawyers. Next slide, please. So let's look at 1.6. And Rule 1.6 says, the lawyer shall make reasonable efforts to prevent the inadvertent or unauthorized disclosure or unauthorized access to information resulting in the representation of a client. Now, this is essentially information security. How should an attorney secure client information? So ABA Rule 498 actually quotes a prior opinion, which is 477R, and it says lawyers must fully consider and implement reasonable measures, and that's a keyword, to safeguard confidential information and to take reasonable precautions when transmitting such information. Now, what is reasonable? Now, the opinion goes on to say it is a fact-based analysis to these non-exclusive factors. So there is no one answer. It depends on the facts. But this opinion and also the Pennsylvania opinion, which we'll go through later, actually gives some guidelines on what those reasonable measures could be. Next slide, please. So AB opinion 498, it states the responsibility does not require that lawyers use special security measures if the method of communication affords a reasonable expectation of privacy. Now, there are guidelines in multiple opinions on whether a certain communication affords a reasonable expectation of privacy. For example, if you're working from Starbucks, if you're using a public Wi-Fi, is there a reasonable expectation of privacy? And most of the opinion says no. Where you work is another area. Can somebody overhear your conversation? See your communications that you're doing with your computer. So things of that sort. And the opinion goes on to say lawyers generally may transmit information relating to the representation of a client over the internet without violating the model rules, where the lawyer has undertaken reasonable efforts to prevent inadvertent or unauthorized access. Now, and factors to consider to assess the lawyer in determining the reasonableness are the expectation of confidentiality, include the sensitivity of the information, and the extent to which privacy of the communication is protected by law or by a confidentiality agreement. So the confidentiality agreement portion is self-explanatory. Now, what are the areas where the privacy of information is protected by law? It could be, even personal information, if it is covered under, a regulation like GDPR or one of the state privacy laws. It could be health information. So any kind of information where there is an increased expectation of privacy, that will affect the reasonableness of the measures that the attorney is supposed to take. Next slide, please. Now, the opinion actually lists a variety of options that an attorney could take. And number one, using secure internet access methods, such as through secure Wi-Fi, use of VPN, or another internal portal. Using unique complex passwords, which is an issue in itself, because the more complex you make a password, generally it is harder to remember. People end up writing them down. So generally, if you want to make a password complex, make it a sentence, something that you will remember, but do not write it down. Implementing firewalls, anti-malware, anti-spyware, antivirus, applying all necessary security patches. Just keep your systems updated. Encryption of data, that's in the formal opinion, but many of the state opinions says encryption is not required unless the data requires a higher level of privacy. Multi-factor authentication to access firm systems, which is pretty standard at this time. And what that means is, in addition to putting the password in, you get a notification on your phone, you enter that code, and only then you get access. Next slide, please. Now, the PBA opinion, and even if you are not in Pennsylvania, this is a very good opinion to take a read, because it gives a lot of actionable steps, concrete steps that you can take to achieve that reasonableness determination. So the opinion says, at a minimum, when working remotely, attorneys and their staff have an obligation to take reasonable precautions. And it lists some of these precautions. All communications, including phone calls, text messages, emails, are conducted in a manner that minimize the risk of inadvertent disclosure. Now, how do you do that? Well, the place you work. That's one thing that you can control, where somebody cannot overhear it. One of the main issues that have come up a lot is when people work from their living rooms and you have devices like Alexa or Google Voice, something like that, that's generally considered not permissible. But something, that we always have to, or just turn it off when, if you have to work from, from a place where those devices exist. Information transmitted through internet is done in a manner that ensure the confidentiality. That goes to encryption. And it is the requirement for encryption, and the PBA opinion actually defines encryption. But the requirement for encryption, it depends on the required security for the information. It depends on the information. The remote workspaces are designed to prevent disclosure of confidential information in both paper and electronic form. And that's a big concern when people work from home. You just have to make sure that, other family members or somebody else visiting do not have access to the client information. Next slide, please. Backing up confidential data stored in electronic devices, not just because of the opinion, but as a general matter, that's a very good practice to do that. Especially when you have issues like ransomware, for example, when people take hold of your data and then ask you for payment to give you back that data. If you have frequent backups, then that takes away that risk to a big extent. Any remotely working staff are educated, and that goes to the duty to supervise under Rule 5.1 and 5.2. Appropriate forms of data security are used. Next slide, please. Now, the PBA opinion actually gives some best practices, and the committee and the opinion starts that by saying the committee is not suggesting that the failure to comply with the best practices would necessarily constitute a violation, but it goes towards the reasonableness should a violation occur. So, these are things that is good to follow. So what are these? Let's look at them. Next slide, please. Specifying how and where the data created remotely will be stored, and if remotely, how the data will be backed up. So knowing where the data is. And why is this important? Because say the representation is closed and you need to return the data. If you do not know where the data is, you cannot return all of the data. In terms of protecting the data, the first thing to know is where the data is. So and this is true across, not just in this setting, but across all settings. If you're looking to secure data, the first thing is to limit the number of places that data exists. So those are the only places you need to worry about securing. Requiring encryption or the use of other security systems. Using firewalls, some of the same things that was listed in the ABA opinion. Limiting the information that may be handled remotely, as well as specifying the persons who has that information. So again, limiting the amount of information that is available is a best practice. Verifying the identity of individuals with access to firm's data. Implementing a return work from home protocol. Requiring the use of VPN. Now, VPN by itself will actually help many of these best practices, because data is, when you access data through VPN, data actually exists in the firm's computer, not on your personal computer. So your obligations to secure the data goes down a lot when you're only accessing data through VPN. Next slide, please. So some of the same things, requiring the use of two-factor authentication, supplying or requiring employees to use secure and encrypted laptops. Now that's getting harder. It used to be that companies and firms used to provide employees with laptops, but now it's mostly bring your own device. So making sure that the devices that the employees are bringing are encrypted and are secure. Saving data permanently only to the office network. Again, this goes back to the use of VPN. Obtaining a written agreement from every employee that they will comply with the firm's data privacy policy. Encrypting electronic records, encryption again. Prohibiting the use of smart devices. We talked about this earlier. In the areas where you work, if there are smart devices, then that could lead to a potential breach of privacy. Taking any other reasonable means. Next slide, please. Now, video conferences like this one are pretty common. And as I said, the PBA opinion gives detailed, very detailed steps on different aspects of working remotely. But I thought I will just put this out there because video conferences are so common. So do not make meetings public. If it's a client meeting, require a meeting password. Do not share a link on an unrestricted publicly available social media post. Provide the link directly to people. Manage screen sharing, and they actually recommend screen sharing for host only. And ensure users are updated, with the version of remote access or meeting application. That goes back to updating all the software you have, making sure all the patches are installed, just making sure the systems are up to date. Next slide, please. Now, the PBA opinion at the very end has something that is completely different. It says, given the circumstances, attorneys should be prepared to agree to reasonable extensions and continuances as may be necessary to avoid in-person meetings. So if somebody requests a remote deposition, there is a PBA opinion out there which requires you to grant it, if not require, which encourages you to grant that. Next slide, please. Caitlin, back to you.
Thank you, Sunu. And I'm going to kick it off with attorney-client privilege and then back to Sunu if we have time at the end of the presentation to talk a little bit about e-discovery. So attorney-client privilege is something that I'm sure all of us remember from law school. It's something that should be top of mind, and my portion of the presentation is going to give you a bit of a refresher on some of the basic principles and also apply those principles in scenarios that are probably common to many of us. So here we're talking a little bit on this slide about what are the basic principles of the attorney-client privilege, being to encourage full and frank disclosure from clients, and clients need confidence to disclose, and attorneys need all the info from their clients in order to give them the best advice. The definition of the attorney-client privilege. There's two key parts to analyzing how you define it. It seems like a basic concept, but gets really complicated when you start applying it to scenarios, as we're going to do in a few slides. So the key elements, one is legal advice being sought, and two is the communication related to obtaining advice and made in confidence. So start off with what law applies. And it can be federal law and it can be state law. I've got two sites here for cases that address both. In the federal law context, that case involved a federal grand jury subpoena. And so it was federal law that governed. In the Montgomery County case, it was underlying state law claims that were at issue. And so the court applied Pennsylvania law in applying the attorney-client privilege. Here's the Pennsylvania scope of the privilege, and it states under 42 PA-CSA section 5928, in a civil matter, counsel shall not be competent or permitted to testify to confidential communications made to him by his client, nor shall the client be compelled to disclose the same, unless in either case this privilege is waived upon the trial by the client. In Pennsylvania, this is the Pennsylvania Supreme Court case Gillard, which holds that in Pennsylvania, The attorney-client privilege operates in a two-way fashion to protect confidential client to attorney or attorney to client communications made for the purposes of obtaining professional legal advice. And that would seem obvious, but for those that are familiar with Pennsylvania and its tortured history on this issue, next slide, please. The Nationwide case, which was overturned in part by the Gillard case that we just talked about, said that the protection is available only in a one-way fashion for confidential communications made by the client to counsel, which, as we saw in the last slide, was changed with the Gillard opinion. So let's go on to a hypothetical in the next slide. Hypothetical 1, a situation that many of you have probably faced. Kathy, the claims manager, received a menacing letter from a policyholder threatening a lawsuit over one of the company's claim handling processes. Kathy emails the letter to Irwin, the in-house counsel, asking what she should do. Irwin then sends a responsive email to Kathy and copies in Randy, who is the RVP who oversees Kathy. So in this scenario, what, if anything, is privileged? And let's break down the different documents here and where the privilege may apply. So is it all three? I don't think so. Is the letter itself from the policyholder threatening a lawsuit privileged? No. Is Kathy's email privileged? Yes, it was sent to in-house counsel for the purposes of obtaining legal advice. She attaches a copy of the letter, the underlying letter, though, which the underlying letter in and of itself is not privileged. How about Irwin's email then back to Kathy, where he copies in Randy, who oversees Kathy? This one gets a little bit more complicated and is a possible answer. Yes, possibly, and I'd probably, at least in the first instance, take the position that it is privileged if I was preparing and reviewing this document for purposes of production. But this answer can vary depending on your jurisdiction and whether the jurisdiction employs the control group or subject matter test to analyze privilege. And whether it's in the control group scenario, which we're going to talk about in a little bit, whether it's only employees involved in the decision that should be included, or subject matter view for obtaining attorney-client privilege. And Randy, because he's Kathy's boss, has responsibility for overseeing her, and is part of the subject matter to know the topic of this email. And under that scenario, it would be privileged. Next slide. So we're going to talk and focus a little bit on the attorney-client privilege in the context of corporations, which is in most situations the context in which many of us will face the attorney-client privilege due to the nature of the work that we deal with. So some questions to ask yourself: who is the client? Who may speak to a lawyer in confidence? And there's no bright line rule. There's lots of questions instead that you can ask and go through this analysis when you're reviewing a document to determine whether it is in fact privileged. And so here's some of the questions to ask yourself. 1, was the information necessary to impart legal advice? 2, could the information have been obtained from somebody else? 3, was the employee talking about matters within the scope of their employment? 4, was the employee aware he was providing information to counsel for corporate advice? 5, were the communications considered confidential when made and kept confidential after? And another point to keep in mind that the lawyer should define who the client is. And a practice tip, whether you're in the role of in-house counsel or working in conjunction with outside counsel, is to seek consensus as to who should get info and discuss with outside counsel, so that you have an understanding of who is within the group, to avoid copying people on emails, because a lot of the times it's the emails that are getting you into trouble or causing questions about where the attorney-client privilege comes into play. And consider restricting circulation to people who, quote, need to know, so that you have a smaller group of people and less of a chance where you're going to see the forwards and the sending on of emails to other people and potentially risking privilege. So keeping the privilege once you have it. Here's some issues we're going to discuss in the next slides. Waiver, disclosure to third parties, who can waive the privilege, and the failure to assert privilege in a timely manner. So who needs to be involved? And this is something I touched on a few slides back. Consider to whom privileged advice and information should be sent. Broad distribution beyond those who need to know can defeat a claim of privilege, and subsequent dissemination might cause a waiver, which is a common problem with emails, and why it's important, and something I do when I'm working on a larger matter where there's a lot of folks involved, is to have a conversation to understand when you're working with outside counsel, or in my case, working with in-house counsel, who are the people that need to be part of the conversations and the emails that I'm going to have with in-house counsel, and have an understanding of who people are, especially when we're in a remote environment and I don't necessarily have an opportunity to meet people and put a name behind an email address. Next. So waiver, which is a bad word in the context of attorney-client privilege. So the extent of the waiver and the general rule, which I talked a little bit about, complete subject matter waiver, whether there's a broad versus narrow interpretation, and the fact that this is largely a fact-intensive inquiry. Is it waiver of just the fact, or is it the document identified by the waiver? Those are some questions that this issue implicates, versus the subject matter. When you have a subject matter waiver, whether it's all communications covering the same subject matter as the fact of the document. Another issue to focus on is whether there's been a partial waiver, and whether the privilege is waived only as far as what was disclosed, and fairness coming into play when you're dealing with waivers. Was the disclosure designed to gain an advantage? And there's case law in Pennsylvania and Illinois that you cannot selectively disclose to counsel to gain advantage. So you can't try and disclose certain things and not others, and use the attorney-client privilege offensively, meaning not as a bad thing, but offensive versus defensive. Next slide. So common misperceptions about the attorney-client privilege, and these are things I'm sure you've heard many times from folks questioning the scope of the privilege. So just putting the lawyer on, make sure you copy me, or having a lawyer at a meeting can give you the cloak of privilege. All communications from or to a lawyer are privileged, or the magic stamp, as we like to call it, confidential, attorney-client privileged. These things alone do not make something privileged, although I will say that having that stamp on does help when you're in mass document reviews, and at least giving the reviewing attorneys a heads up that this is something that may contain privileged information. So not for naught, but not necessarily the end of the inquiry in terms of figuring out if something's privileged. So continuing on the theme of common misperceptions, if I tell the lawyer a fact, that fact is now privileged. And privilege is absolute. Well, no. There is definitely a crime fraud exception, wherein there is a client committing or intending to commit a crime. The focus there is on the client's intent, which is key to that exception. And then there's something called the overriding public concern or strong public policy considerations, which you'll see in the case law in New York and New Jersey, which basically is a test that the courts use to balance the gravity of the public interest and whether you can obtain something that is privileged, that you argue is privileged from a less intrusive source. So multi-state companies. The privilege applies even if in-house counsel is not licensed in the state at issue. And the case that I've got cited here is a Middle District of Pennsylvania case, the Scranton Products case, which ultimately held that communications with an in-house counsel were privileged since he was licensed to practice, even though he was licensed in a different jurisdiction. He just needed to be a member of the bar, was the key factor in this case, although he did face a possible violation of the rules and was referred for disciplinary authority to disciplinary authorities. Another situation in the attorney-client privilege context is privilege when you've got multiple parties involved. And this is, again, a scenario that many of the folks on this listening to this presentation have probably encountered. There's a potential for waiver of privilege as documents and information are shared among the parties, and it gets complicated in these scenarios. And I've often used a joint defense agreement to help alleviate some of the concerns there. It's also complicated when you have in-house counsel for an insured involved in a transaction, which you'll often see where you have somebody playing both roles, where they're involved possibly in underlying real estate transaction that generates the title claim, and then involved again in the context of bringing the title claim. And that can get complicated. And I had that situation just this past year where it was a claim that the attorney that was involved with the real estate transaction missed the name change, which was that case that I mentioned in my last presentation with the John Doe and Doe John. And the attorney who had reviewed the title policy missed that. He ultimately then was the same attorney who brought the title claim to the title insurance company, and then ultimately was brought in as a named defendant in the case. So in my encounters with him, I was dealing with him not only as essentially the client, but then also as a co-defendant. And that gets really complicated, especially in the title context where you do have people wearing multiple hats, or anytime you have somebody wearing multiple hats. And so it brings up multiple issues of the insured's duty to cooperate, the common interest doctrine, counsel's duty to disclose, which was implicated in that case I just mentioned, and getting informed consent of the insured, which was something I had to deal with when we had the insured's attorney then becoming a named defendant, and the possible conflicts that can result in that scenario. So lots of complicated. I think the takeaway is just that it can get complicated, and just talking through and thinking through some of these basic concepts should help walk you into the right answer. So here's some helpful takeaways to remember as you're dealing with this issue and trying to figure out attorney-client privilege. The 5 W's and an H. So who control with whom you communicate, what control what is discussed, where control the location of communications and documentation, when control timing, why make the request for advice explicit, make sure it's clear that someone is seeking attorney-client protected information, and how insist on an appropriate process. There's some takeaways to help you remember. So preserving the privilege, document the purpose of your communication, document separately the legal aspects of the communication. And for those of you that are wearing multiple hats, don't use your non-legal title in legal communications, and don't mix legal and non-legal communications. Be careful who receives legal communications and where the communications are stored, something Sunu touched on in our prior presentation, and avoid complacency, especially as we drag on in this remote work atmosphere. These are just some things to help you remember as the end of the year approaches, and also when you're in a crisis situation. So a lot of times when the most interesting and critical privilege documents come up are the ones that the emails that are being fired off late at night or fired off in the middle of a crisis situation, and try to just remember privilege and how to protect it so that those communications do in fact stay protected. Okay, moving on to a related topic, the unauthorized practice of law. We got a nice visual there of a caution sign. Next slide. So the rule of professional conduct 5.5, the unauthorized practice of law. Read here the rule that's on your slide. A lawyer admitted in another United States jurisdiction or in a foreign jurisdiction, or a person otherwise lawfully practicing as an in-house counsel under the law of a foreign jurisdiction, may provide legal services through an office or other systematic and continuous presence in this jurisdiction that, okay, I'm going to hold your attention by announcing the second CLE code. CLE code number 2 is on your screen, and I will read it aloud. 05302. Again, that is CLE code number 2, 05302. All right. So continuing on, this slide continues on the rule for Rule 5.5, the unauthorized practice of law, and details the circumstances when it is not. A practice tip, and you can all read the rule as it's stated on the screen. Get licensed where you have an office. We looked earlier at a case out of Pennsylvania which held that you could still have privilege even if you had an office in another jurisdiction, but you still had the issue of an ethical violation. Where there's also case law, though, in New York that held that you're not an attorney when giving advice in a place that you're not licensed. So that's something to keep in mind. All right, next slide, please. So outsourcing legal work, this is something I'm sure many of you have done and will continue to do. Cited here, the ABA Formal Ethics Opinion 08-451 and State Local Bar Association opinions, with the concept being that it's okay to outsource to a non-lawyer or a lawyer that's not barred in your jurisdiction. I'm sure many of you do that all the time. But you must, by applying professional skill and judgment, set the appropriate scope for the non-lawyer's work and vet the non-lawyer's ultimate work and ensure its quality, which is something you should be doing anyway. But in the context of ethics, it's important to remember. So the ABA opinion provides that strict supervision of outsourced legal work is key, which is adequate supervision, maintain consistent and open lines of communication, check references, and ensure that the quality of the work completed is satisfactory. Next slide. I have a case cited here, and these are cases if you need to look back later and look for an opinion, helpful to have the J&J manufacturing case, which ultimately held a legal malpractice claim due to alleged failure to properly supervise electronic discovery that resulted in the inadvertent production of privileged documents. Hopefully for most of you that are on this call in the in-house role, that's a task that you're delegating to your outside counsel so you can avoid that situation. And then the Syracuse products liability case, the ultimate responsibility for ensuring preservation, collection, processing, and production of electronically stored information rests with the party and its counsel, not with the non-party consultant or vendor. Important thing when you're thinking about using vendors, which I know we use, and I'm sure many of you have used. And the last case we're going to talk about in this portion of our presentation, outsourcing legal work, which is a Northern District of Illinois 2011 case. Privilege was waived where the counsel failed to quality check their e-discovery vendor's work before production to opposing counsel and inadvertently produced all documents previously marked as privileged. That is certainly my nightmare, and a situation which can waive privilege. And with that, I'm going to wrap up my portion of the presentation, and this is the end of you all hearing me speak. I'm going to turn it over back to Sunu and my co-presenters, and I enjoyed this presentation. And just a reminder to everyone who's not speaking, if you can please mute, double check that you're muted. I see a few folks that are not on mute. We can hear you. Thank you.
Thank you, Caitlin. Yeah, so Caitlin touched on a couple of cases on e-discovery, and we'll talk, briefly on this topic. This is a huge topic by itself. Decisions are coming out almost, every week, and most firms have an e-discovery practice group, just like us. So this is a very vast area, but we'll just, aim to touch on a few high-level points here. Next slide, please. So what is the rule of professional conduct that is applicable to e-discovery? One of them is 1.1. So the lawyer shall provide competent representation to a client, and competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary. And that competence means issuing timely litigation holds, but that's not enough. Next slide, please. Rule 3.4, lawyer shall not unlawfully obstruct another party's access to evidence. So if you are not producing all relevant documents, we could be in violation of Rule 3.4. Next slide, please. Other thing to think about is Federal Rules 37E, but this only apply when information is lost before a duty to preserve arises. So a court could, if a party failed to take reasonable steps to preserve the information, the court could, upon finding prejudice, may order measures no greater than necessary to cure the prejudice, if it was not intentional. And then let's go to the next slide, please. Upon a finding that the party acted with the intent to deprive another party, then a court could do any of these things. Presume that the lost information was unfavorable, instruct the jury that it may or must presume that information was unfavorable, or even dismiss the action, though that's very rare. Next slide, please. Now, what are the implications of these rules, both in terms of rules of professional conduct and also the federal rules? That essentially requires us to take some affirmative steps to monitor compliance with the litigation holds, especially as in-house counsel. Understand the discovery obligation and duty to safeguard the client information. Next slide, please. And judges have, in surveys and also in some opinions, have essentially said that they want to see a greater participation from in-house counsel legal teams for all aspects of legal discovery. And this mainly because many times it is the in-house counsel who knows the information or who knows where the information is. So in terms of litigation holds and lack of or a failure to preserve the information, in multiple surveys, judges have indicated that they would like to see more participation from the in-house teams. Next slide, please. So let's look at a few cases which show some potential issues. So this first one is from Florida, from Middle District of Florida. So in this case, no litigation holds were put in place, no preservation instruction disseminated, and relevant data was lost. The general counsel was sanctioned for fees and cost, as was the defendant, with adverse inference and with fines. Next slide, please. The next one, the in-house counsel failed to preserve evidence. Although he had taken several steps to protect information, he did not supervise or approve the copying and wiping of laptop and hard drives. So in this case, he had taken some steps, he just did not follow through. Thus, when that information was no longer available, the defendant was determined to have a culpable state of mind regarding the failure to preserve. So this is meaning to do the right thing, but not following up. Next slide, please. In this case, the court recognized that in-house counsel did not establish any meaningful document retention program and made those adverse findings. Next one, please. Now, what's an example of doing it right? So this is a case from Connecticut, where the employee sued a former employer and alleged that employer withheld documents during discovery. The court found that company's in-house counsel had satisfied the company's discovery obligations. And what are the steps that the courts noted? Well, they issued a timely and detailed litigation hold to all potential custodians, then giving instructions to ESI custodians regarding searches, specific search parameters. And that one is a major issue in e-discovery, not just in the document preservation stage, but even later on when you are doing document collection. Because many times, or at this time, the way we do business is entirely by email or mostly by email. So when you start a litigation and start the e-discovery collection process, the amount of documents that are out there are so huge that you need to do search terms. And the issue of these search terms has been the subject of multiple decisions. And generally, courts have said, well, you guys know the information better. We are not going to say which search term to use or which one not to use. So come to an agreement between yourself. And if you cannot come to an agreement, we are going to apply a special master. So there are multiple cases that have gone in that direction, but search terms are very crucial, because if a search term is pretty broad, then you will essentially end up with a lot of irrelevant documents, which you have to go through the expense of reviewing and producing. So explaining the importance of a thorough search to ESI custodians. And that goes back to both the outside counsel and the in-house counsel, because people who have this information may not know about the ESI searches, electronic discovery, all those different things. So educate them, that's a duty. Providing guidance when questions arose during search. So these are the things that the court observed that somebody who did everything right performed. So something to use as a guidance. And I think that ends our presentation. Any questions? To either Caitlin or myself.
Well, Sanu and Caitlin, thank you very much. And if there are questions, you can submit them. We're going to take a 5-minute break, bathroom break, drink break, but we'll start promptly back in 5 minutes. During the break, I just thought I would raise a few issues on this ethics that I have found is an issue over my many years of representing insureds. As we all know, there's this sort of unique dynamic where you have in-house claims manager, claims counsel, you have your assigned counsel who is representing and is counsel for the insured. And you have, as I said, you have in-house claims counsel who manage the matter, but are not the insured's counsel. And I think that one of the first ethical issues that pops up just because of that dynamic is for when the claims counsel starts to communicate with the insured about their claim, and they're looking at the claim, determining what the defense is. I mean, not the defense, but what the action might be in terms of in order to defend the insured's title that's being challenged or has a problem with. You must make it very clear to them that you are not their counsel. And just because you may or may not provide coverage, you are not providing them with advice and so forth. And that if outside counsel is assigned, that's their counsel. And again, one of the issues is defining what it is that an assigned counsel's role is vis-a-vis the insured. What is it that they're counsel for, and what are they not counsel for? Specifically, and in particular, when there is instances where there is a reservation of rights. So from an ethical point of view, you don't want to lead the insured to believe that you're somehow providing them with counsel for too broad of issues, and you certainly aren't acting as their counsel when you're in-house. And I thought it was interesting also, Sanu's comments regarding the cybersecurity, again, and not cybersecurity, I'm sorry, the search for ESI. A lot of times I've found that insureds are reluctant to spend the time and effort to do the searching that needs to be done. Sometimes they hedge and say they don't have the documents. And it's a very interesting dynamic where you have outside counsel, assigned counsel, trying to get their client, the insured, to do what's necessary to produce certain documents, or at least to find this and see if there are documents. And then during that process, outside counsel sort of determines that maybe they don't have the greatest litigation hold in place, or they never really retained any of their documents, and they destroyed certain documents, knowing that they should or possibly should have retained them. What is the role of the outside assigned counsel at that point? What type of communications can they have with inside managing counsel about the failings of the insured. In one instance, if there's just simply a failure historically to retain documents, perhaps that can be revealed to in-house managing counsel. But other things, given the fact that there is that attorney-client privilege and relationship between the assigned counsel and the insured, certain things that are found during discovery cannot be revealed to the managing counsel, and some of those issues may in fact go to whether or not coverage should be denied or revoked. Those are very difficult issues, but some of the issues that at least can be and should be discussed with your outside counsel in a general way when you've developed that relationship with the firm or with the lawyer over time, so that they understand and everyone is on the same page. I think that's really important so that there is no hiccups going forward with cases where some of those issues can arise. Anyway, those are my very limited comments on that. And we're coming up on the end of our break. I want to move into the last hour of our presentation. And again, thank you for being here. And I think that this is going to be a really informative last third, where we're going to deal with specific issues and questions about how does an in-house counsel claims manager, what's their role in preparing for trial and what's their role during trial. We have both Steve Applebaum and Zach Burke, who both are on our title trial team. And I know Zach has tried at least 3 cases for some of the underwriters who are on this matter. So I know he has a very unique perspective on interaction with claims management, claims counsel, as he is preparing for trial and then when he goes to trial. So with that, I'm going to turn it over to both Steve and Zach for the last segment of our presentation.
All right, thank you, Tripp. If you can't hear me, if anyone can't hear me, please let me know. As Tripp said, my name is Zach Burke. I'm a litigation partner in the Saul Ewing Boston office. As Tripp mentioned, I've tried several title cases. I handle and manage a lot of title matters. In addition, I manage a lot of real estate related litigation and just general commercial litigation. What we're going to discuss today, preparing for trial, just really go through a lot of different things that should be on top of your mind as outside counsel, sort of as in-house counsel, managing outside counsel, things that you should be looking for your outside counsel to be doing to make sure that everything's in order in case you do ultimately end up at a trial. If you could flip to the next slide, please. This slide says taking discovery with an eye toward trial. And this is generally an overview of what we're going to be talking about. I think it might be a better title might be positioning your case with an eye towards trial, because we're not going to be solely going into or discussing discovery related issues. In any event, we understand that there's a wide range of experience among people attending this program. So some of what we discuss may be new ideas to some, and for other more experienced attorneys, we hope our discussion will at least serve as a good refresher and maybe give you some new ideas about what to look for as the case goes along. Now, when a new litigation matter comes in, oftentimes the initial reaction is to assume that the case will settle, and the focus becomes how to best position the case for settlement. Other times you might think that the case is certainly going to be disposed of by a dispositive motion, especially in these title cases, which frequently depend on legal interpretations of contracts and various conveyancing instruments. But as we all know, this is never a guarantee. And it's understandable that those are the first thoughts, given that roughly 97% of cases resolve somehow short of trial. Judges, however, obviously can be very unpredictable. And no matter how sure you are that your case presents purely legal issues, the judge might not see it that way, or simply might not understand the intricacies of title law. And you can end up in the precarious position of facing a trial in a case that you view as purely presenting an issue of contract interpretation. And this almost happened to me recently. We were representing an insured against a claim by plaintiffs that they held title to an insured's parcel of land as a result of an out-of-sequence recording when a family subdivided several lots in the early 1980s. A few months after this out-of-sequence recording happened, someone realized that it could potentially cause a title problem, and another deed was recorded, pursuant to which the couple who had erroneously been conveyed one of the subdivided parcels then conveyed it to the initial intended grantee. And that grantee was in the insured's chain of title. However, the plaintiffs in this case claimed that the deed that was recorded to clean up the sequencing error was defective. They argued it didn't satisfy the statutory requirements for a quitclaim deed in the jurisdiction, and as a result, the parcel was never conveyed back to the intended grantee, and it remained in the plaintiff's chain of title. And this seemed to us, right out of the box, that no question this was a matter that could be resolved on summary judgment. The principal primary issue was this subject deed a quitclaim deed as a matter of statutory law or not? So we went ahead, filed the dispositive motion, and you guessed it, the judge said there were issues of fact that needed to be decided at trial, and this was even though the plaintiff's counsel agreed that the claims presented purely legal issues. Now, ultimately, there's a happy ending with this story. The parties agreed to submit an agreed statement of facts and file for summary judgment, and then the judge ruled on that summary judgment in our favor. But the point of the story is you should always be looking at a case with an eye towards trial from the outset, and so as not to get caught flat-footed. So what should you be thinking about? And these are the issues we're going to be discussing today. What are some unique considerations for title cases? What forum are you in? What forum would be beneficial for your case? What evidence will you need admitted at trial? And who are your key witnesses and what testimony should be preserved? And we're going to get into these in more detail. Before I'm going to turn it over now to my colleague, Stephen Applebaum. Before I do that, I'll just mention that the CLE code number 3, it's on the slide here, it's 90431, 90431, and take it away, Stephen.
Good afternoon, everyone. My name is Stephen Applebaum. I'm a partner in our South Florida offices. My practice is primarily based in business and contractual disputes, and with that, real estate, because Florida's economy is heavily based on real estate and tourism. I've handled a large and varying range of title disputes, and I'm pleased to speak with you today. So title defect litigation tends to fall into several general categories or buckets, and sometimes the case follows more than one general fact pattern. The slide on the screen lists the various categories of title defect issues that I have litigated. And a common thread is that most cases in the title insurance context usually hinge on publicly recorded documents that are central to the dispute. Some cases come down to a general agreement on the facts, like Zach was just mentioning, but there's disagreement about the application of law. For example, in lien priority contests, there's often general agreement about the date that each of the instruments were recorded, but disagreement about which lien is superior or subordinate. That may depend on the applicable notice statute, whether you're dealing with a pure notice statute, a race statute, or a race notice statute, intervening events or litigation between those recordings, or other factors. By way of example, several years ago, I represented an insured who had purchased a property from a lender who successfully completed the foreclosure process. After the insured purchased the property, a foreclosure suit was filed. That foreclosure suit was brought by a mortgagee whose interest arose and was recorded during the prior foreclosure action and after a lis pendens had been recorded, putting that mortgagee on notice of the pending foreclosure. The mortgagee chose not to intervene in that prior foreclosure action, instead opting to try to foreclose on our insured years after he had purchased the property. In that case, minimal discovery was needed because the parties stipulated to all of the material facts. Instead, it boiled down to a legal question: whether the prior lender's lis pendens barred enforcement of the after acquired mortgage. We did take the deposition of the other side to lock in their position and to get their stipulation as to the authenticity of certain documents and dates of recording of publicly available instruments. The parties then filed competing summary judgment motions very early on in the case, and we ultimately prevailed on behalf of the insured. Our summary judgment was affirmed on appeal without a hearing. Other cases, however, are more factually driven. For example, cases that often require development of the factual record commonly involve forgeries or fraudulent conveyances, survey and boundary disputes, and adverse possession matters. In forgery and fraudulent conveyance cases, the factual question is commonly about who executed the deed or mortgage. Sometimes the person who forged the instrument is related to the party who's challenging the forged instrument, like in the case of spouses, which my colleague Caitlin had touched on earlier. I've handled several cases where the borrower contests his or her signature on the deed or mortgage and thereby challenges the enforceability of the security instrument or the conveyance of the property. This challenge is what triggers the claim in the title policy by the lender in most cases. In cases where the signature is being challenged, as a starting point, I pull all of the documents that the borrower signed in the low file. I also search the public records to try to find other examples of signatures in loan documents, mortgages, or other documents that are public available that don't relate to the disputed issue. Handwriting experts, which I will discuss later, can also be very helpful, but there are some other less expensive avenues as well. One tactic I've used when signatures are being contested is to request an early mediation. Prior to the mediation, I asked the mediator to require that all of the parties sign in before entering the mediation room. Unsuspecting parties sign in using their authentic signature, and I have used those sign-in sheets to effectively demonstrate during mediations or after that the signature on the sign-in sheet and the signature on the disputed instrument match, and it undermines any argument that the signature was a forgery. In cases challenging the authority to convey the property, the issue is often a mixed question of fact or law. In several cases I've handled, the property is owned jointly by the husband and the wife, and it's sometimes the homesteaded property. There are often questions about whether the property can be encumbered without both spouses' signatures, or whether a lien attaches to a property jointly owned. In adverse possession cases, there's usually extensive discovery taken on the length of time a property is possessed, whether the possession was open and obvious, how the property was used during the relevant duration, and other fact-driven elements needed to support the claim. Adverse possession actions necessarily require often a lengthy look-back period and can be a challenge at times to find witnesses who are familiar with the usage of the property from 7, 10, 15 years, or sometimes 20 years previous. Interviewing and deposing witnesses who are familiar with the property and using those witnesses to authenticate relevant documents like photographs can be very important. In survey and boundary disputes, graphical aids and pictures are critically important. The adage of pictures are worth 1,000 words ring true here. An aerial photograph of the property in question is a helpful tool and can be a persuasive way to help communicate the issues in dispute, whereas a meets and bounds description is abstract and can be cumbersome. My colleague Mike Joyce earlier touched on reformation statutes that attempt to take errors in deeds and mortgages outside of the litigation realm. However, if litigation is necessary, the cause of action of reformation often requires proof of intent, which sometimes can be inferred from the documents, but intent is also a factual inquiry that opens the door to potential parole evidence to explain why the documents included or did not include certain language. Next slide, please.
All right, back to me. I'm going to talk about some forum considerations now. And obviously, different forums can greatly affect how a case proceeds to trial and how it's positioned once you get to trial, and ultimately how a trial proceeds once you're there. So I'm just going to discuss different things now to think about when a case first comes in and you're sending it off to outside counsel, and what should be the considerations with regard to the forum. So first of all, I'm going to start talking about pros and cons of federal court versus state court. Obviously, there's often no choice about the forum in this regard, but again, making that determination as to whether there is an option about the forum should be done at the outset of every case. And I'm not going to get into the intricacies of diversity, jurisdiction, and federal questions, because that could be an entire presentation or course in and of itself. And in discussing the differences between these forums, I'm speaking in very generalized terms, because obviously different federal and state jurisdictions can operate very differently. A state court in New York City might operate very differently from a rural state court like my colleague Mike Joyce mentioned earlier out in West Virginia. With that said, as a general matter, federal courts, in my experience, have more resources, including law clerks and magistrate judges, and a lighter docket, and therefore, if you have a case where you're right on the law, there's a better chance that a federal court judge will be able to dig into the legal nuances and grant a dispositive motion. For the same reasons, if you have a case that, for whatever reason, might need a lot of judicial oversight, for example, you just know when a case comes in, there are a lot of parties, there's a lot of discovery issues that are going to arise, you might have better luck with a federal court judge. On the other hand, if you're on the other side of the coin, with a case where the insured may be the more sympathetic party, even if the law might favor the other side, then in that instance, maybe you want to be in state court. But also think about which forum, federal or state court, is more familiar with the legal issues that are likely to arise in the case, and whether or not that familiarity is a good thing or a bad thing for your case. I have a case right now where a key issue is whether Fannie Mae is a government actor when it's under a conservatorship with the FHFA, the Federal Housing Association. The plaintiff in that case is arguing that it is a government actor, and therefore it's a violation of due process for Fannie Mae to hold a non-judicial foreclosure. Now, I haven't done an analysis whether this case could proceed in state court, but the federal law is favorable to our position, and therefore I wouldn't want a state court judge trying to weigh in on these issues when there's a ton of federal court precedent that supports our side of the case. Another consideration to think of is how many depositions will you need to have taken in the case, and how long will those depositions need to be? As I'm sure many of you know, federal court only permits 10 depositions for each side of the V in a case. And if a case has a lot of parties, that could present an obstacle. Federal court also limits depositions to 7 hours. Massachusetts, for example, where I primarily practice, has no limit on the number or the length of depositions. And that could be something that's important depending on the case. Another thing to think about when you're considering forums is there a specialty court where the case could proceed that you might want to consider? For example, again, I'm going to refer to Massachusetts. We have a land court department of the trial court, which has jurisdiction over most title-related cases, and that's concurrent jurisdiction with the Superior Court. So you could be in land court or Superior Court on many of these cases here. In the land court, you get judges who are very familiar with real estate law and title disputes. So when I'm in land court here in Massachusetts, I don't need to worry about whether the judge will understand that title insurance is not a guarantee of good title. That may or may not be a good thing for your case. In land court here, you get more judicial oversight. You'll get a thorough written decision after a bench trial in land court. However, some of these specialty courts have limitations on jurisdiction. Here, if you need to bring a counterclaim for money damages, the land court doesn't have to take jurisdiction over that case. Are these good or bad things for your case? These are just things you should think about at the outset. I'd also implore you to ask your outside counsel what intel can they provide to you about how the specialty court operates? Can they provide a meaningful scouting report on the judges that might inform where, if you want to bring the case or move the case to the specialty court, if that's an option, and just think about how that will impact the selection of the forum. Another question is, who is the ultimate fact finder in the forum? Again, here in land court in Massachusetts, there are no jury trials. So if you think a jury would be beneficial, obviously you don't want to be in land court. But that consideration should be considered for every jurisdiction. Just a few general considerations about forums, in addition to what I've already mentioned. Think about how quickly does the docket move in each forum, and whether that's a good thing or a bad thing for your case. Who's going to benefit from having more time to prepare for trial? Is the other side simply interested in delay? I have, and I'm sure many of you have had, several foreclosure-related cases where the plaintiff's counsel, their primary goal is just to delay as long as possible. They know substantively they're going to lose the case, and they just want to delay. If that's a case that you have, where can you, what forum can you put that case into where you're going to get it moved more quickly? Most title-related claims that I deal with have been equitable in nature, and therefore, at least in Massachusetts, there's no right to a jury trial. That may be different in different parts of the country and depending on the subject of the claims. But if the claims will be decided by a jury, you'll want to think carefully about what the jury pool will look like in different venue and forum options. Is it going to be a sophisticated jury? Is it a plaintiff or defendant-friendly jury? Will the jury, for one reason or another, have sympathy for one of the sides in the case? These considerations can inform, once you're in a forum, they can inform your settlement position, and they can also inform how you want to frame your case for trial. You know, what is going to be a key issue for the fact finder that you're going to want to emphasize when you get to trial, depending on what forum you're in. Now, that's a lot to think about, but these tactical decisions, as I mentioned at the beginning, these decisions that you make at the beginning of a case can make a significant difference when it comes time for trial and how the case proceeds at trial. Now I'm going to turn it back over to Stephen to discuss some issues concerning the admission of evidence.
Thank you, Zach. The general rule for the authentication of documents is that the proponent must produce evidence to support a finding that the item is what the proponent claims it is. In most instances, the authenticity of documents is not contested, particularly in title cases where the documents central to the dispute commonly are recorded in the public records and are relied upon by all of the parties. For example, the chain of title or the liens that encumber the property are based on instruments that are recorded in the public records. Certified copies of those records can be requested from the clerk in the jurisdiction where the documents are recorded, and often include a stamp with important information like the date the document was recorded and an instrument number and the book and page number where the document can be found. That recording information is critical when putting together a timeline of key dates for trial. In most jurisdictions, certified copies of public records are self-authenticating, meaning that extrinsic evidence of authenticity is not needed to get the document admitted into evidence. Also, commercial paper, like promissory notes, are self-authenticating. Tendering the original note, as opposed to a copy of the note, is critical. The same goes for allonges. If the note has been sold or assigned, the allonge must be the original wet ink allonge as opposed to a copy in most jurisdictions. However, there are instances where proving the authenticity of certain documents is necessary, like where a party disputes the signatures on a document or where the business records of a financial institution are questioned. It is important to anticipate challenges to the authenticity of documents early in a case and to find ways to establish the authenticity, whether through deposition testimony, business record affidavits, or through the use of expert witnesses. Let's touch on challenges to signatures and where handwriting is at issue for a moment. It is possible to authenticate handwritten evidence through non-expert opinion, to prove the genuineness of the handwriting based on the non-expert's familiarity with the person's handwriting. However, this witness's familiarity must not have been acquired solely for purposes of the litigation. Instead, this person must be familiar and knowledgeable about the handwriting outside of the litigation, like a coworker who may be familiar with someone's handwriting or a family member. Handwritten material can sometimes be authenticated by a neutral decision maker like a judge. That judge would be asked to compare the writing in question with other handwriting samples that have already been authenticated. More often than not, however, a handwriting expert is necessary. Choosing the right handwriting expert with the right set of credentials is important to qualify the selected expert. It can also be important to leverage to get the other side to drop their challenge to the authenticity of signatures on the handwritten documents. In one case, I retained the former chief fraud examiner for the US Secret Service to compare signatures on certain loan documents. When I disclosed this person as my expert, the other side was quick to withdraw their challenge to the signatures. Next slide, please. During the deposition phase of a case, it is important to consider authenticating documents you want to use at trial. Oftentimes in title cases, the business records of a lender or a title agent or the owner of a commercial property are important. Authenticating those documents during the deposition of a fact witness can be critical. If the deposition is of a corporate representative, you should consider in your deposition notice to designate as one of your areas of inquiry familiarity with the business record keeping or filing system of that business. Authenticating business records during a deposition is a helpful tool to present the other side from challenging authenticity as trial approaches and from preventing you from taking last-minute depositions to establish the business records exception. To lay the foundation for business records to be admitted into evidence, it is important to ask if the witness is familiar with the business record, confirm it is the company's business practice to prepare such records, confirm that the record was prepared in the ordinary course and scope of the business, that they were prepared by someone with knowledge, that they were prepared at or about the time the matters reflected in the records occurred, and if that's the regular part of the business to keep and maintain those records. An issue I have faced with increasing frequency is challenges to business records held by successor lenders. Loans often change hands many times. In the foreclosure context, borrowers' counsel challenge whether a successor lender can authenticate business records created by prior lenders 2 or 3 steps removed in the chain of assignments. In Florida, as well as many other jurisdictions, the courts have allowed successor lenders to authenticate the business records of prior lenders who once owned the loan, if the current lender can show indicia of reliability and explain the onboarding process of the loan, and whether that onboarding process included independent verification and reconciliation of important facts and figures. The courts have recognized that the secondary market for buying and selling loans could crater if successor lenders could not reasonably rely on the records of their predecessors and authenticate those records at trial. I've never faced this issue, but I thought it was worth mentioning for survey and boundary disputes, Federal Rule of Evidence 803-20, which establishes as an exception to the hearsay rule, the reputation in a community arising before the controversy concerning boundaries of land in the community or customs that affect the land, or concerning general historical events important to that community, state, or nation. When signatures to documents are challenged and call into question the authenticity of the instruments, witnesses to the signatures can prove important in establishing whether or not that signature is what it purports to be. In Florida, for example, mortgages must be signed in the presence of a notary public and 2 subscribing witnesses. It is sometimes necessary to take the deposition of the notary and the witnesses. Oftentimes, those witnesses will not specifically remember whether they witnessed the document in question being signed, but you can establish the customary procedure for witnessing documents and get them to rule out that they deviated from that procedure. In one case, We were representing the lender who was foreclosing on a celebrity, and that celebrity's a very expensive house off of Miami. I needed to take the deposition of the notary and the two subscribing witnesses. And one of the witnesses happened to be a sitting circuit court judge who had worked at the real estate office that handled the closing several years previously. Although she had witnessed many signatures during her time as a private practitioner, she did remember this particular document being signed given the celebrity status of the person. And it was important to lock in that testimony for purposes of trial. The case did end up settling, but to have a sitting court judge saying that she remembers witnessing the signature, I think went a long way in recognizing from the other side's perspective, they faced an uphill battle in challenging the signature on that document. And I'll turn it back over to Zach.
All right, thank you, Stephen. I'm going to talk about trial witnesses, which obviously, in addition to making sure that all the evidence you need gets admitted at trial, who your witnesses are, how they testify, whether they're properly prepared to testify is crucial. What witnesses are going to testify at trial should always be top of mind during discovery. And there are really two categories of witnesses to think about. First, what witnesses will you need to prove your case and the elements necessary for your case? And two, who is the other side going to call as their witnesses? Now, with regard to the former, at some point well before the close of discovery, and I like to do this as soon as I have a grasp of the parties' claims, counsel needs to look at the elements of each claim and figure out what evidence will be needed and who can help either provide relevant testimony or testimony to authenticate key documents so you get everything in a trial that you need. Some title companies require us to provide detailed case analyses. While sometimes we might not get those to you as quickly as we'd like, and I apologize for that. I think those are generally very helpful because you really need to think through all of the issues in the case while putting those together, including what evidence you need at trial and what witnesses you're going to need to depose and then call at trial. Similarly, sometimes judges will require, depending on the court, detailed memos early on in the case for purposes of helping manage discovery. And that's really another opportunity that outside counsel can use to think through the trial witnesses, and that you as title counsel, a claims counsel, can look at drafts of that and provide your own thoughts. If you're dealing with an adverse possession claim, for example, and in Massachusetts, there's a 20-year statute to prove adverse possession. Will you need to track down former owners of the subject property, their relatives, neighbors, former neighbors? I mean, that can be a very big undertaking and is going to need a lot of forethought about how to do that and how and who's going to be available to testify at trial and how to get that evidence in at trial. I have a case right now where a witness's bank statements are relevant. And as Stephen mentioned, there are several things to think about to ensure that similar documents are admissible when you get to trial. With regard to who the opposing party is going to call as witnesses, it's critical to serve in every case and make sure your outside counsel is doing this, an interrogatory asking them to identify anybody with relevant information to the subject claims. And then once you're taking depositions, have them ask each witness that same question: who has information? Now, while it may depend on the nature of the case, the safe fallback position is always depose each witness identified by the other side. I know that might be an expensive proposition, but it's really rolling the dice if you don't do that. And you put yourself in a better position when you come to trial if you've already done that. On the other hand, if there's a disinterested third party that might have relevant information, one way to deal with that is if you don't want to go through the cost of a deposition immediately, interview that third party informally if they're willing to talk. Again, you don't want to get caught off guard by unexpected testimony. Taking as many depositions as possible, obviously, will let you know what you're dealing with and will inevitably provide some opportunity to impeach the witness at trial and create some doubt about the witness's veracity. I recently tried in the spring a 5-day adverse possession prescriptive easement case in Massachusetts concerning a commercial parking area. The plaintiffs in the case disclosed, 6 or 7 employees who had information about the use of the parking area. We deposed all of them. I think it was about 6 employees, and we asked them all the same questions about the frequency of the company's use of the parking area. We got about 5 different answers from the witnesses about how many cars were parked in this area during a typical day. And then once we got to trial, almost every witness gave a different answer than what they had provided at their deposition. We were able to contrast all the differing answers and that helped us cast doubt on their story, whether they were telling the truth or whether they were just simply making this up in order to support their employer in the claim. Now, you might, as I mentioned, you may save some cost by not taking certain depositions during discovery, but that could really end up burning you big time at trial if there are a bunch of witnesses you don't know what they're going to say, and then you don't have ammunition to cross-examine them when the time comes. With regard to interviewing friendly witnesses, as I sort of alluded to earlier, maybe you have a case where there's a neutral witness, such as a neighbor, and you're not sure whether it's worth the time and expense to have counsel take that person's deposition. Oftentimes, I'll make arrangements to try and interview the witness over the phone if they're willing to do that. And if the witness does have helpful information, then you really need to think about how you want to preserve that for trial. You could take the witness's deposition, but there is a risk with that the testimony might not be identical to what was said during some informal discussion, and then you might give the other side some opportunity to get some testimony at a deposition that's going to be hurtful to your case, helpful to their case. Another option is you could, if this informal interview reveals some helpful testimony, you can have the witness sign an affidavit. And depending on the discovery request at issue in the case, you may or may not have an obligation to disclose that affidavit before trial. But the affidavit will help ensure that that witness, if you do need to call them at trial, doesn't do a 180-degree turn on their testimony following what they told you over the phone or in some sort of informal interview. I have a good example of this from a recent case where having an affidavit would have been helpful. The case I mentioned that went to trial in the spring, we interviewed a disinterested witness in that case early on during discovery with regard to the plaintiff's adverse possession claim about the use of that parking area. We later interviewed the witness again a second time, and his story was entirely consistent and somewhat helpful, but we didn't think it moved the needle much. And so we didn't think it was worth taking his deposition, and we weren't really planning on calling him at trial. Well, fast forward several months later, when it came time for trial, we were reconsidering whether or not to call this witness because of simply the number of witnesses that the other side was going to call. And we thought, well, we might want to try to balance that out with some people who would be helpful to our case. So we did a third interview of this witness about a week before the trial. His story, again, was consistent. It was somewhat helpful. So we decided to go ahead and serve him with the trial subpoena, and we called him during our case. Well, what do you know, when I started questioning the witness during the trial, his memory all of a sudden was much less clear, much less definitive than what he had told us over the phone. He wasn't giving us the helpful sound bites that he repeated 3 times during our interviews. And although it wasn't damaging, it wasn't really helpful to our case. And I actually ended up cross-examining the witness a little bit and learned that he spoke with opposing counsel and the other side in the case about a day or 2 before his testimony. And I used that to make it clear to the judge that his testimony had been compromised by those conversations. However, and thankfully this wasn't damaging, again, because it wasn't a key witness. Otherwise, I wouldn't have taken this chance by calling him at trial in the first place. But in hindsight, if we had obtained an affidavit from him after we initially interviewed him, we could have used that to impeach him, and he would have been much more likely, having had signed an affidavit, to have that he would have stuck with his original story. Now, I'm going to sort of shift gears here and talk about selecting experts. It's key to think early on in a case, how many experts will you need? If the case is a title dispute regarding the interpretation of property boundaries, do you need a title lawyer to interpret a deed or other conveyancing instruments, and or a land surveyor to lay out where the boundaries described in the deed are physically located on the ground? Or you might need a surveyor to just testify that the boundaries can't be located on the ground, depending on the claim. Do you need an appraiser, maybe a real estate broker or a closing attorney or a handwriting expert? Now, while the temptation may be to wait to get these experts involved in order to save cost, because hopefully a case will settle, it's often very helpful for outside counsel to have these experts retained early on, because they can help provide valuable input into the claims and inform the approach to discovery from the very beginning. And that can be helpful, and even if you don't end up at trial, help set up the case for a favorable settlement. Also, with regard to experts, think about who you want to use. How relevant is the expert's experience? How well credentialed is the expert? It's always a good idea to research and have counsel research the written opinions in your jurisdiction or where the expert's located, to see if the expert's opinion has been accepted by courts or rejected by courts before. Right now, I'm using a title expert for a trial that's coming up in February, who I previously used with the same judge in another very similar case, where the judge found the expert to be credible at trial and he ruled in our favor. And that's a huge advantage going into this trial, with the judge knowing our expert and trusting our expert. Another thing to think about with regard to trial witnesses is the witness order at trial. Now, how you do this and go about it really depends on the case, and it's more of an art than a science, but it is something that should be thought through several times before trial begins. Typically, your first witness will be someone who can provide the most background about what the relevant factual matters are to help paint the picture for the fact finder. And I typically like to sprinkle in less interesting, less critical witnesses in the middle of a trial, and then start and end with the most important witnesses, because the first and last witnesses are likely to be the most memorable. Another thing to think about with your outside counsel is whether you want to call an opposing party during your case. I've done this in cases when I'm representing the plaintiff and I have a ton of ammunition from the defendant's deposition. If you can cut the other side off at the knees before, from the start of the case, it can be nearly impossible for the other side to rebuild their credibility. Another thing to think about is deposition designations. If you depose a witness who is unavailable for trial, the deposition and the designations from the depositions will need to be designated. The deposition transcript, will need to be designated for trial. Counsel is going to need to think about how much background information is needed. Obviously, what is the key testimony, whether to object to counter designations for any reason, et cetera. This can be done, this should be done as early as possible, and you as claims counsel could help provide some, outside perspective as to whether or not those designations are appropriate, whether they make sense, whether the testimony will make sense when it goes into the record. If you have a bench trial, one thing to think about is whether you're going to submit the designations on paper or have them read into evidence. If you are going to read them into evidence, who's going to do that? It could be very beneficial for you to be able to select the person who's going to be representing the witness. And I'm not advocating that you hire an actor, but you could, by who you choose, if it's counsel from another attorney at the firm, just the impression that they give off could be valuable. Now, sort of related to deposition designations, a question to think about when taking depositions of potentially unavailable trial witnesses. If a witness is in another jurisdiction and you won't be able to subpoena them to appear at trial and you don't have control over them, do you want to take that witness's deposition by video? That can be, I think that testimony, if it's good, can be very compelling and much more compelling than reading a transcript at trial. However, there are other things to think about. I recently had a case where we didn't control a key witness. He had left the company. He was out of state. He was the one primarily dealing with the subject transaction at issue in the case. But he was a big personality, and we thought he was somewhat of a wild card. And if we videotaped it, if it went well, it could be great. But we thought it was just too risky to videotape that deposition because if that witness didn't perform well in the video, that video at trial could do more damage than it would do. It would be helpful. So we ended up not videotaping that deposition. Something that always comes up, it seems to always come up before trial, is the other side in the case lists witnesses who they're going to call at trial who were never previously disclosed. So that's just something to keep an eye out for when there's a final joint pretrial memorandum that gets filed with the court. If that happens, most of the time in my experience, the judges will either prevent the witness who hadn't been disclosed from testifying, which is obviously a good thing, or at least give you the opportunity to take that witness's deposition before trial so you're not going in cold. With regard to witness preparation, again, this is something that should be thought about well in advance of trial and really well in advance of depositions. Your counsel and you, with your input, should determine how much work will each witness that you control need in order to be in the best position to testify to their best at trial. It might require a handful of calls and in-person meetings over the course of months if the witness is really critical, but just doesn't have a grasp of the facts or just needs a lot of coaching. I find that oftentimes, and you might want to suggest this to your outside counsel, that you send witnesses that you control, send them witness binders of key documents that they can get to know well in advance of depositions, so they know them cold by the time depositions come and then by the time the trial comes. And this is obvious to everybody, but practice, practice, practice. The more repetition you have with these witnesses, the more you can focus them on the key issues and how to testify. Because no matter how well a witness knows the facts, a trial is a unique setting and it requires a lot of preparation. And witnesses, you need to get the outside counsel needs to get the witnesses to understand this, because they may think, I know this case well, I lived it, I know what happened. Knowing that is a different thing from being able to explain it on the witness stand in a way that is helpful to the underlying claims. And the more you practice, the more you can get them to that point. One last thing I'll mention, it's not on the slide, but I find I've had a couple trials where claims counsel attended the trial, and I find that to be very helpful because claims counsel is in a great position to sort of observe everything that's going on and help just provide little nuggets of advice during a trial that are helpful. What impressions, what impressions are the witnesses making? Does claims counsel, in observing the trial, have any thoughts about the judge? What type of evidence is landing with the judge? Is the judge nodding, shaking his or her head? Is there anything where you can tell that the judge is really focusing on certain pieces of evidence? That type of information is very valuable to trial counsel and can help sort of steer the way you try the case as you're going along. Another thing that can be valuable from claims counsel from attending a trial is advising the attorney who is trying the case whether or not they think the evidence, should they move more slowly? Should they move more quickly? Do certain points need to be emphasized more? are we beating a dead horse on certain issues and we should just move on because everyone gets it and people are getting bored? Just having that perspective is very valuable. And finally, just other tactical decisions, because you obviously can't prepare for everything that happens at a trial. Things come up and quick decisions need to be made that are very important. And just having claims counsel there to discuss those issues is extremely valuable. With that said, I think we are finished. So we were going to open it up to questions about preparing for trial, and I think about any of the topics that were covered today.
Well, thanks, Zach and Stephen. I really appreciate it. We are at the end, but I want to open it up to any questions on any of the topics. So we'll give so if you have one, you can unmute. You don't have to necessarily turn your video on, but you can unmute and go ahead and ask the questions. Well, it sounds like we must have done a really good job covering all the areas. I thought the last presentation, as with the other ones, was excellent. Give you a real sort of idea of what to think about, both generally as an attorney, but also within the sphere of title insurance claims, both for defending, a title for your insured, but also if there's any coverage disputes or issues that unfortunately might get to trial. So with that, I want to thank everyone for attending. We really appreciate it. We appreciate all those individuals who we know, and we hope to get to know more of you as well. And with that, enjoy the holidays, stay safe, and we'll talk to you real soon.
Thank you.